Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. If you haven't gotten enough of me today, guess what? You're in for a special treat. Before we begin, please like and subscribe if you want to hear more content. I promised you an update in the Kouri Richins case, and finally, we do have an excerpt from their proceeding on Friday the 5th. Yep. So, the judge in this case, again, is protecting the jury pool. He does not want things to be publicized in a quick fashion. So, Law and Crime was there. That I can see the recording is terrible thus, but maybe it might get better. And which we will go ahead and play for you. So, we'll watch that together. It's only about 30 minutes or so. But before we do, please make sure you like and subscribe and tell all your friends. I got to get more viewers. Get the word out. So, want to try to get to 100 viewers before the end of December. We're at December 9th. So, let's go. Come on. All right, my lovely law nerds, let's go. So, we're going to do a quick. Who's Kouri Richins? Kouri Richins lives in Utah. Actually, she lives in Camas County, which is just outside of Salt Lake City. She was married to Eric Richins. Something happened to Eric. These are their lovely family photos. Kouri was a real estate magnate. She would go and buy houses and flip them. This is her $2.9 million mansion that she purchased after the death of Eric Richins. So what happened to Eric? Short story is that Kouri Richins wanted to get rid of her husband, allegedly. Prove innocent until proven guilty, right? So and February 14th, she had given him a fentanyl sandwich in which he had a very bad allergic reaction to it. And what does that mean? It means that he almost passed away, but he didn't. So she said, I guess I need more, right? So she contacted her go-between who contacted the dealer, and she got more fentanyl. Eric Richins died of 5 times the legal limit of fentanyl in his system. Kouri says, hey, I made some cocktails. I gave him one. But there's in the motions, there's no proof that she gave it to him. And there's no proof that the cocktail had fentanyl in it because they didn't know how Eric died. So it was a very long time before they realized it was her. And why or how is that? Well, she had given them her phone, the police her phone, and guess what? If you don't give the passcode, they can't break into it. Took them a year and a half to get into it. Finally, when they did, they saw all the text messages between her and the go-between and put 2 and 2 together that she might have given him the fentanyl. So why did she do it? Well, she did it for insurance money, potentially. Eric had a couple of policies. And also, Eric had a lucrative job and had a great bank account. She might have wanted the money from that, but we do know she is also being accused of financial crimes, where she took the bank statements from Eric and copied and pasted her information on the top and her information on the bottom with all of his financial information in the account to help her buy that $2.9 million mansion to flip it. Long story short, Kouri Richins is in jail. She did write a book. So she has 3 boys, as you saw in the pictures earlier. She wrote a book, Are You With Me?, to help with the grief of her children at the loss of their father. She even went on radio and television promoting the book, knowing all well she alleged to have done it. So the walk the dog letter. This is what it looks like, people. This is a bone of contention. This will come up later on before the pretrial hearings because this train is going. She is headed for trial. The walk the dog letter is several pages long, and in it is stated several different things. 1, Kouri is telling her brother and her mother how they should remember how things happened. She stated that this letter was to be given to her attorney for attorney-client privilege, and then at another time it was stated that she's writing it for a book. People, when you're in jail, you write something, unless it's like specifically in an envelope for your attorney, guess what? The people at the courthouse read it. They give it to the people who are prosecuting you. It can be used against you. Okay, not telling you how to crime, but hey, this is where we're at. All right, so she's got a new defense team because the other defense lawyer was conflicted off the case. We already talked about it, so here we are. There was a pre-trial conference hearing scheduled for the 5th of December. We're going to look at that just now. There is going to be 2 more pre-trial motion hearings on the 7th to talk about expert witnesses, and then the walk the dog letter, and then jury selection is set to begin on the 10th, trial set for the 23rd. Now, I have not watched this conference. We're watching it together. All of these dates and things could possibly change. So let's get into it. Let's take this, move this. Here we go. This might be a little bit wonky because long crimes, things a little bit wonky, but nonetheless, here we go.
500162, State of Utah versus Kouri Richins. Mr. Bloodworth, on behalf of the state, Ms. Richins, this is a new set of charges. We've handed you a copy of the information showing.
Oh boy.
Do you have that?
She's got some new charges.
I don't need to read it to you, unless you'd like me to.
We've read it.
All right, very good. I am
Oh
appointing
man.
Wendy Lewis, Catherine Nestor, and Alexander Ramos to appoint to represent Ms. Richins in case ending 162, at least through the first scheduling conference in that new matter. And we're going to set that. How about April 17, Council? Is that agreeable?
So far away.
Mr. Bloodworth?
Yes, sir.
At 1:30 p.m. April 17, 1:30.
I wonder if these are her
Mr.
financial
Bloodworth,
crimes.
anything else on the new case?
No, sir.
So it's hard to get a hold of the docket. You have to pay a lot of money. And I don't have enough subscribers yet. So subscribe if you want me to get a hold of the docket to see what these new charges are. But I'll find out eventually.
Okay, sorry, Your Honor.
That's okay. April 17, 1:30 p.m. for a scheduling conference. We, Brittany, will inform the county manager that you've been appointed on the new case through that date at least. Okay. Anything further on that case, Ms. Lewis?
No, Your Honor.
Okay. Let's return to case ending 139. We're here for a pretrial conference. Mr. Bloodworth, what is it that your team wanted to address today?
Your Honor, I think we should briefly discuss the, just to kind of maybe review what we're expecting for January 7th and January 8th motions hearings. The state then would like some of the court's guidance on filing, whether the court prefers non-public filings in the motions in limine practice and subpoena practice. We should probably touch on jury instructions a bit. The parties have reached an agreement to extend some of the briefing deadlines that we'd like to put on the record, I guess, or just let the court know.
I saw those. We'll talk about those. We can go over those. I just need to make sure I have enough time to read, so I'm prepared for the 7th and 8th.
Understand?
Yeah.
And then there's one kind of reminder for the court that Greg White's motion for a protective order, docket 933, has been fully briefed and requests to submit for decision.
Is that? Yes, I recall that from the first trial setting. It was unclear whether that was mooted by the resetting of the trial.
I don't think
been
so.
Resubpoenaed
Exactly.
to appear?
Right.
Okay. Okay, it's on the list. I got it.
That was what was on the state's mind, Your Honor.
All right. Let's talk about January 7 and 8 first. And perhaps you can
I'm
all give me a
sorry.
better sense of what has not yet been filed but is likely to be filed to be
The
heard
quality
on
is so
those
bad.
things.
There's
So
nothing I can
in
do.
terms of things that were filed prior to the first trial setting that have not yet been decided, I think there's defendant's motion to exclude the state's expert witnesses, which is fully briefed, right?
Yes, sir.
Are we anticipating any supplementation or amendments on that one?
No, sir.
Yes, sir.
Yes.
They just, they just noticed up a brand new expert, and I anticipate adding him to the list of people that I want to exclude under 702.
Will it be a new motion telling me why that particular new
Yes.
person? Okay.
But I mean, you asked about supplementing, and I'm probably just going to, I mean, it's going to be a new motion, but
Right.
it makes sense that we hear all of them together. So I look at that as just like one more objection under that ground.
Yeah, I think, with Rule 702 motions, right? The
Correct.
devil is in the details.
Correct.
So it'll have to be specific to that expert's
Of course.
proper testimony. Okay, I understand. So another expert-related motion to exclude is likely coming.
Yes.
Okay.
In Your Honor, I think the parties are in agreement that the experts, I guess whoever they are, on January the 7th can appear by WebEx.
Okay, very good. Are we doing any of, and forgive me, I didn't go back and pull all the briefing. To what extent will we be doing any of their, or viewing or reviewing any of their expected testimony and declaration, or are they going to do a trial run on the 7th? How much is happening on the 7th? What's your expectation, Ms. Nestor?
So
Have you received summaries or reports from the experts?
we have received both, actually. My only concern about is if we only rely on the summaries and the declarations, that if we don't prevail on the motions and then it expands at trial beyond what we argued, then we're right back to where we started. So it would be my preference that the experts take the stand and make sure that we fully understand, exactly what the limits of their opinion will be, is so that the court can rule on it all at once.
I don't know that we set aside enough time for that kind of exercise.
Right.
3, 4.
I mean, how many experts are we talking about?
Right now, the experts that have been challenged are the FBI profiler,
Right,
the domestic violence expert,
right,
the handwriting expert,
sure.
and then this new one. So there will be 4.
Okay, so let's take the domestic violence expert
Right.
as an example. I understand your position to be there is no factual nexus between that type of expert in this case. Under 403, it shouldn't come in.
Right. We also have issues with her qualifications.
Okay.
Yeah.
Her qualifications are what they are. Either
Yeah.
they meet the standard. There's no allegation that she's lying about them on her CV, right? They're either good
Right.
enough or they're not.
Right.
Okay. What does she need to testify about on January 7th?
Well, the nature of her opinion. So it's my understanding that she's
Haven't you received a report or a summary of them?
a summary. Yes.
And based upon that summary, you're persuaded that there's no fit, to use the word, the 702 language between her opinion in this case?
Right.
Your Honor, if I may jump in on 2
Yes.
things. One, I don't
Come on,
believe
Mr.
they've
Bedley, let's
consulted
go.
with her yet. And 2, she's not offering an opinion.
Then why is expert testimony appropriate at all?
She
Yeah.
she's testifying about characteristics of domestic violence relationships, but she is not offering an opinion as to the relationship between the defendant and Eric Richins.
Understood. She, as I understand it, will be offering specialized knowledge that is beyond the knowledge experience of a lay
Right.
juror.
Correct.
And then the state's intention would be to make argument using her testimony as foundation.
Correct.
I understood that.
That makes sense.
I'm not precluding you from asking that person questions. I'm just not sure we'll need much to fairly address your arguments regarding that testimony.
I agree.
The FBI profiler, I just don't know. We'll find out, I guess. Mr. Throckmorton, there I can appreciate why you might want to voir dire him a bit about what he didn't do, didn't look at. I think we'll have sufficient time for that. Do you have he usually produces a report with exemplars. He has a standard form. You've received that. So you'll be able to jump right in with him on the 7th. You wouldn't need the state to lay any direct testimony.
No.
Okay. And then who's the new one?
It's, I mean, I guess let Mr. Bloodworth answer that.
Your Honor, it's a detective with experience in.
Oh, that's right. Yes. Illicit drugs in Salt Lake County in a certain time frame.
Correct.
Got it. Okay. And you've received a summary or a report?
I don't think we've got that.
Your Honor, just a summary.
Okay. All right. Well, I stand corrected. I think we'll be able to get this done. Whether I'll be able to rule on all this by the end of the day on the 7th, I'm less certain on, but we'll figure that out. Okay. All right. And then I'm jumping around here a little bit, I apologize. Would the intention be to hear oral argument on as many of the motions in limine that the court wants to hear oral argument on the 8th?
I think that makes sense.
Your Honor, that makes sense. I think there might some, I guess, depending on what the court's interested in hearing, might require testimony.
Give me an example a little bit. They'll be fully briefed, right?
Yes, sir, they will be fully briefed. Your Honor, some of the factual allegations in the defense's motion in limine, I don't think they're supported. It's not like a lot of times the state can say, we agree to this proffer because we know you could prove that.
Right.
I don't think that's the case through many of the factual assertions in the defense's motion in limine.
Which, give me one that sticks out in your mind. I perused some of their defendant's motion limine. I thought I looked at it.
Mhm.
Are you trying to say that their characterizations of what the state would be seeking to admit are not accurate?
Your Honor, there is that in the motion, but I also think that we can address that in the written briefing.
Right.
I think that the
Which
some
one?
of the factual allegations, I know there's not a facts section of the briefing, so it's just difficult to, in a sense, tease out the
Right.
factual allegations, but there are factual allegations. Paragraph 1, after the death of her husband, Miss Richins and her son wrote a children's book together. That
I don't need to make
To
that
the extent
finding, though.
to the extent the court that's just the first example, but
Okay.
to the extent the court needs to make factual findings, there may be a need for the court to take testimony.
Okay. I think to the extent there is a dispute about what a piece of evidence says or doesn't say, what a witness is going to be offered and testified to or not, there may need to be some back and forth among counsel. Hopefully that'll get teased out in the briefing. We may need to lock some folks in. We also need to recognize that, especially with live testimony, sometimes witnesses turn left instead of right, and we're going to have to be a little bit nimble during trial to say, well, that ruling no longer applies. We have to make some amendments. So,
Yes, sir. Sir, my sense is, since we'll be together on the 7th, if at the latest on the 7th, but as early as possible, if the court recognizes potential factual disputes and will give us a heads up, we can have witnesses ready.
okay, I would hope to do it before then. This is a good way to back into, under your stipulated extensions, when will the motions in limine that you can contemplate sitting here today be fully briefed?
Your Honor, the agreement that the parties have reached really only relates to the defense's motion in limine, and it is a 1 week extension for the state's response and an additional week for the defense's reply. That would put the state's response due on December the 24th and the reply due on January the 7th.
All right. Can we move the reply date a little bit?
January 5th.
I mean, that's like right on top
Yeah.
of what they're at. So
Yeah, at least
January
I have to read
5th,
it on
okay.
the 6th. Okay. So that would be defendant's reply in support of their motions.
Correct.
Okay. January 5, Ms. Lewis.
Yes.
Thank you.
they are going to be working through New Year's Eve. Busy.
Mr. Bloodworth, I need a binder and a thumb drive on January 2nd. And it needs to have, the binder needs to have the briefs that I'm considering on the 7th and 8th. And the thumb drive needs to have PDFs of the brief plus PDFs of any exhibits.
Yes, sir.
Okay. Understanding that the reply brief we just talked about won't be in it.
Sure.
Okay. All right. Okay. Back to the list. We've talked about defendant's motion to exclude the state's expert witnesses and a forthcoming additional motion in that regard. We have the state's motion to determine the admissibility of the walk the dog letter. That is now fully briefed and just submitted for decision, correct?
Correct.
Your Honor, actually, that was submitted for decision 8 months ago. I can do it in writing, but I object to the reply that was filed 8 months later and move to strike the reply.
If you do it in writing, give your reasons why, and then we'll give the state an opportunity to respond to the motion to strike, and I'll consider it. Okay. State's first notice of intent to offer 404B evidence, that has fully briefed, but there's a second notice, correct?
Correct.
Is that second notice fully briefed yet?
Your Honor, it hasn't been briefed at all.
Okay. Is there a plan for briefing it?
Your Honor, we've not discussed one, but
Okay.
the state's open to whatever.
We're going to respond before the 12th as
Okay.
we were directed. And then I guess they can reply. So I thought we had a briefing schedule for all the motions that were filed on the 26th, I believe. According to the docket, our response is due by the 12th.
Okay. Very good. Mr. White's motion for protective orders on the list. I haven't lost track of it. There were additional motions limited filed by the state recently, correct?
Yes, sir. And may I note too, there's the motion in limine related to the orange notebook that was filed back in, I don't know, early 2025 that has not been fully briefed
Or submitted for
or
decision.
submitted. But we spoke with defense or emailed or something with defense counsel the other day. They know it's out there. They plan to submit a response.
Okay.
And then the state will either reply or submit.
I know it seems silly, but in any docket, and especially one of this length and complication, the request to submit is literally how the court knows whether to pay attention to something or not. It's the difference between me leaving open the possibility that you all worked it out in the process of the briefing versus knowing I need to pay attention to it and how quickly. So please follow that procedure so I make sure I don't miss anything. Okay. Let's talk about private versus non-private. I take a rather expansive view, especially given the proximity to jury selection of what can be filed privately in this case, especially if counsel agree. If you all agree that a specific particular return of service or all returns of service, subpoenas or all subpoenas, all motions in limine should be filed privately to prevent incomplete, misleading, or just absolutely inaccurate reporting of the content of those documents from poisoning the jury pool, I will not get in your way.
Understood.
Any objection, counsel? No. Yeah, you don't need to. The procedure that the parties have been following on both sides of the V is acceptable to the court. The benefit of
He's talking about you law nerds. You're reading the filing and stuff like that, and you might be misleading the juries. Now, I did say that she was innocent until proven guilty, right? But I just laid out what was already in the papers and the filings. So I'm just telling you the story. Let's continue.
of doing it as a private document is that you all can see it, I can see it, court staff can see it, the public cannot. And there's good reasons for that given the proximity to jury selection.
Yes, Your Honor, the state appreciates that. The state would ask, just as a courtesy, if counsel files non-public, if they could send us a courtesy copy. We don't have access electronically to non-public. You have to walk down to the court's office.
Is that true?
It is.
Don't you have the same green filing access that everybody does?
We don't use green file, Your Honor.
Oh, is that a government thing?
It's a government thing.
Oh. That is
Oh,
news to me.
interesting.
I apologize.
The judge didn't know that.
So the state appreciates the non-public filing this close to seating a jury, and the state will engage in it itself. But filings after hours are,
Right.
we don't get them until the next morning. When we walk down.
Is it a simple matter of your office just buying a green filing account for a couple of months?
It may be. I don't
Okay.
know how it works.
Fair enough. I'll let you all work that out. I did not appreciate that. Okay. Yeah, there may be a way we can work around that for you.
Thank
Okay. Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, anything on that? You
They've been in this
folks
case
through
for a
green
couple of
filing
years
are
now. They're just
instantaneous.
don't have green filing.
Okay, very good. Any
We'll work on
objection
getting you
to
one.
what I've just proposed?
No.
Okay. All right. The juror questionnaires are scheduled to go out on December 16th. You've received a copy of it. We included the changes that Ms. Shervanek emailed over after a meet and confer some months ago at the end of October. One additional question came up. Do we want to include a single additional question asking the juror if they're paid hourly or salary? I don't know if that's something you'd want to know when culling or creating categories.
Why would that matter? But
There are certainly other fields where someone who believes the financial hardship would be
Right.
too great would have an opportunity to tell us. Yeah. If you're comfortable with the way it is, that's fine.
We're fine with the way it is.
Okay. Ms. Shervanek.
Yes, I'm fine with the way it is.
Okay. Very good. We are intending to send questionnaire responses to counsel on or before January 19th. Those will come in the form of a PDF and an Excel spreadsheet. We are also keeping a separate Excel spreadsheet of people that the court strikes in advance of them filling out the questionnaire because they tell us, hey, I'm going to be in Europe for 3 of those weeks or things like that. We'll keep a record of it so you'll be able to recreate it if necessary.
oh, that's nice. The court preempting the
Anything
strikes.
else on jury selection?
That's
Mr. Ramos?
awesome.
No objection. Okay. Ms. Shervanek?
No.
All right. Did we get through your list, Mr. Bloodworth?
Your Honor, jury instructions.
Yes.
So at this point in time, we've gone back and forth. We have a proposed set of jury instructions and then a separate document that lodges some defense objections. How would the court prefer us to submit those?
I recall in the run up to am I recalling this correctly, in the run up to the last trial, there was the stipulated set, then there was a set of defense proposed that were not stipulated, states proposed that were not stipulated. Is that accurate?
That is not, Your Honor. We never got to jury instructions
Maybe
in the
thinking
run up
about
to
it.
the
Okay.
prior trial. This is our first go at that.
Okay. I thought we had it. Yeah, and my apologies. I'm getting my cases confused.
Sure.
That's typically the most helpful, is a stipulated set with citations to authority, if in the footer, if possible.
Right.
And then to the extent that the state or defense has a subset of proposed instructions that are not stipulated, just submit those separately with citations to authority. The real question is, to what extent do you want to be able to talk about your instructions during your openings? If you do, we need to come to rulings regarding as many instructions as possible prior to giving openings. If you're less concerned about that or have no intention of doing that, we don't. Some instructions we simply won't be able to finalize until we see how trial proceeds.
I think probably
Mr.
the
Bloodworth.
only one we would use in opening would be the presumption of innocence and burden of beyond a reasonable doubt,
Yep.
which we've stipulated to those two. So, well, there's one additional one we're asking for. So we might be able to just resolve the ones we want to use for opening, and then whatever ones they want to use.
What
Are
is it?
there-
Tell us. Tell us.
Without
Tell us.
getting into too much detail, are there any live disputes or genuine disputes regarding what the elements of the charges are?
There are.
Okay. That seems like an issue
Of
that
course there are.
we should try to resolve prior to opening.
Agreed.
Yeah.
Okay.
You have to have the elements, or otherwise you can't present a case.
Bear with me.
Come on, people.
If I well, if I canceled a civil trial, I could liberate February 19. We want to talk about your instructions on February 19th.
Yes.
Okay.
Okay, jury instructions talk
It's
is
the day after the last scheduled day of jury selection. I'm cautiously
February
optimistic
19th.
we will have picked a jury by then.
That's a Thursday, correct?
It is.
he said he's optimistic
Okay, let's
they
plan
would.
on. Let's plan on. We plan on 1 p.m. on. I have a criminal. I have a criminal count on Wednesday. 1 p.m. on February 19th in person for a discussion of jury selection. Jury instructions. My apologies.
Jury
Mrs.
instructions.
Nestor, does that work?
Yes, Your Honor.
Yes, sir.
Okay. In that case, what I'll need is given that it sounds like there's a dispute regarding the elements of the charges, just a little bit of briefing. It doesn't need to be long, but I just need to know what your position is and why before I walk in on the 19th. Something along the lines of a pocket brief, a citation to authority, a little bit of discussion so I can know what you're relying on. You can only do so many things at once. Can we have those briefs just cross in the mail and be filed on February 9? Does that seem workable, Counsel?
Yes, sir.
Mr. Bloodworth?
Yes, sir.
Okay. Very good. Mr. Bloodworth, keep going.
Your Honor, that's all the state had.
Okay. Mr. Ramos, Ms. Nestor, Ms. Lewis.
We have nothing else.
Could I persuade you folks to just check in with me on January 2nd to make sure we're on track? Is that workable? You can even do it by WebEx if you prefer.
What time would you want to do that?
The afternoon. Brittany, would you recommend the afternoon? In the afternoon.
That should be fine.
Do you want to say 3 p.m. on January 2nd? Would you like to do it in person or by WebEx?
WebEx.
Okay. Mr. Bloodworth, Ms. Sherman, is that all right?
Yes, sir.
Okay. Let's have a continued pretrial conference on January 2 at 3 p.m. to make sure we're on track. Give me just a moment. Mr. Bloodworth, there is a motion to reconsider the severance.
Yes, sir.
When will that be fully briefed under the same schedule?
No, sir, that schedule's advanced. We didn't shift that schedule, so it's the normal. Actually, we gave. Yeah, so next Wednesday will be defense's response. So that's the 10th, and then the state's reply would be due December 17th.
Okay.
The docket says that all of our responses are due on the 12th, so if we could just clarify, we thought, I pulled up the docket, it says the 12th.
I don't have a dog in this fight because I won't know about them until they're fully briefed. But if you have any, I mean, I'm sure you and Brad can.
I don't care if it's the 12th.
Yeah.
We may have some on the 10th, I just don't know yet.
Okay. I haven't read it. I only looked at the caption,
Sure.
but that feels like one that I could rule on the briefs. Any objection?
No objection. I think you can roll on the briefs.
Okay, very good. I will endeavor to get a written ruling out on that as quickly as possible,
Yes.
so that you folks know whether you're trying the amended information as it looks now or something else.
Yes.
Okay. All right. Let me just pause for a moment, see if anything else comes to mind. Go ahead. I imagine they're going to come in with the briefs on January 9th. I'll be more explicit. January 9, I need your briefing on jury instructions to the extent they're disputed in your stipulated set. That's a February. February, my apologies. Yeah. Yeah. Stipulated set, disputed set, and why I should rule one way or the other on the disputed instructions. Jury instructions tend to be an iterative process in any case in general, and certainly a case of this size. And so we may have to discuss them over time as we iterate through. Okay, let me go around the table one more time. Mr. Ramos, anything else today?
Oh, you're right.
Okay, Ms. Nestor,
No, Your Honor.
Ms. Lewis.
There.
Okay, Mr. Blood,
No, yeah.
Ms. Sherman,
No.
Mr. Burmester.
No.
Mr.
No, you're wrong.
Ms. Olson. Okay, Counsel, I appreciate seeing you in person. I look forward to working with you on this case. We'll be back together by WebEx on January 2 at 3 p.m. If anything comes up between now and then, I'll do my level best to make time on my calendar and get you in. Ms. Richins, I wish you the very best. We're off the record. Thank you.
All right. Wow. Okay. So that was the quickest but most informational pre-trial conference hearing I've ever had. They were all over the map. I think this judge normally he's like, okay, what do you got? 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 But there was a long period between the last update and this one, and a lot of stuff is coming back and forth, and they're filing this and they're filing this, and he just is like, well, I am so confused. So just in timeline, on the 12th of December, they're all supposed to reply to some motions here and there. And again, or the 17th. Again, you see, it was like, well, this and this, and this. Something about an orange notebook. She has an orange notebook. And then also talking about whether the filings are going to be private or non-private. And that is the issue. So we, as the public, will probably not be able to get any of the filings, and we're just going to be in the dark, which is fine. And then when they go and argue these things, we'll see whether or not they are or aren't televised. Then we have moving forward. Again, he keeps going backwards and forwards. So he's going to do a check-in on the 2nd of January with all of the parties involved. What do you have done? What don't you have done? Where are we? And are we still on the right track to continuing what is happening? On the 7th, they again are going to have that motion hearing about the something about non-public subpoenas, more stuff about jury instructions, but they are going to have the experts. The defense would like to have the experts come in and do, come in and testify. There's got a new detective about illicit drugs, the FBI profiler, the domestic violence one seems to have gone away. And then I don't know what this other one is. So we'll find out whether or not these experts come on the stand, whether they can testify to some things prior to coming into trial. Then on the 8th, we've got a whole bunch of motions that they're still arguing about back and forth, so they want to tidy those up. But it is the walk the dog letter, whether or not it's going to be admissible. You heard one of the defense attorneys said, hey, judge, like we talked about it before, so they haven't replied to it, so we want it kicked. But he's going to be like, nah. So they'll come back to us on that one. So maybe next two televised are the 7th and the 8th. I don't think we'll see the one on the 2nd. All right. Then they keep going back and forth about jury instructions. So the jury instructions are, hey, it could also be, there also might be talking about the juror questionnaire, because they did talk about the juror questionnaire a little bit, stating that the jury instructions were due to the questionnaire for the jury is to go out by the 9th of February, I want to say, and that he is optimistic that they would be brought back to them by the 19th. So again, and then jury stipulations, whether what you're going to be able to say the jury instructions, etc. So again, this thing is headed for the dates that I put here. They are headed, so they want jury selection to begin on the 10th. I don't know whether or not that's going to happen. And he said something about the 19th. So who knows? So I will kind of compile all of this. Oh, excuse me. I'll compile all of this together. And, this is pretty much our update. So I'll try to write up some more and give you a quick, brief overview. So thanks for joining me in reference to the Kouri Richins case. It is headed for trial in February. Now, whether we know if that is the exact path we're headed for, we don't know. Remember, things can always change. They always fluctuate. If they don't get the things that they need from the jurors, remember they said they were going to expand the pool. That could push things back. So stay tuned. Make sure you like and subscribe so that you can get the latest updates in the Kouri Richins case. And of course, if it is televised, I'm your girl. We'll be there with daily updates. So please like and subscribe so you can find out when the latest and greatest information is. See you again later. Thanks for watching Legalese 1, 2, 3. If you like what you saw, please like and subscribe for more content.